Hello, my name is Larry Falbe. I'm an attorney with Miller Canfield in Chicago, Illinois. Thanks for taking a look at this video, which is entitled Environmental Compliance, Self-Audits, and Self-Disclosures. I hope you find it helpful and informative. First, a few words about me and my firm. I've been practicing environmental and regulatory law for over 20 years, having graduated from DePaul University College of Law in Chicago. Miller Canfield is an international law firm with over 275 lawyers and paralegals spread across 13 offices in the U.S. and internationally, including China, Mexico, Poland, and Canada. Founded in 1852 in Detroit, Michigan, Miller Canfield is a full-service law firm offering legal and business advice and services in many different industries, including particularly the automotive industry. We have a substantial Chicago office from which we serve clients in Illinois and all over the world. Today, we are going to discuss environmental compliance, self-audits, and self-disclosures. Our agenda for today is to look at self-audits and voluntary disclosures. What are environmental self-audits? I have a multiple choice question here which you can't answer because you're watching this video, so we'll have to answer it together. Choice A, a vital tool in ensuring environmental regulatory compliance and avoiding regulatory entanglements that can affect operations. B, a helpful tool in managing risk, often a first step towards a comprehensive risk management program. Or C, a cheap insurance policy against penalties. And of course, choice D, all of the above. As you might expect, the correct answer is choice D, all of the above. Environmental self-audits can serve all of these purposes. An environmental compliance audit is governed by ASTM Practice E2107 number 6, which was reapproved in 2014. The definition of an environmental regulatory compliance audit under the ASTM standard is a systematic, documented, and objective review of an audited entity to evaluate its compliance status relative to audit criteria. What does that all mean? It means that when you're investigating a facility to see about their environmental compliance, you want to have a program that's systematic, you want to then document it, and then you want to make sure that the objective review is completed by environmental consultants and also attorneys. There are also other helpful tools, including some published by US EPA and various state EPAs. So why perform an environmental self-audit? Environmental self-audits can be performed by an internal EH&S personnel, that's environmental health and safety, external consultants, or a combination of both. Self-audits are often part of a comprehensive environmental compliance program, and those are typically performed on an annual basis. Self-audits can be used as a basis for a later self-disclosure of identified violations, which I'll be talking about in the second part of this video. Legal counsel can be involved to help protect audits under attorney-client privilege and attorney work product doctrine. As you can see from the photograph, environmental attorneys sometimes get to go out in the field and do environmental investigations, but we don't typically wear the hazmat gear like the real consultants do. See if you can pick out the environmental attorney in this photo. Otherwise, sensitive audit results typically can be requested and obtained by regulators in the context of an inspection and/or enforcement action. So when identified by regulators, penalties for environmental violations can be severe, including paying large monetary penalties, taking corrective action, or even shutting down operations. And I should note that most recently, OSHA and US EPA have greatly increased their penalties, which makes the risk of being found in violation of environmental regulations and OSHA even more severe. In the most extreme cases, criminal penalties can even be asserted against individuals who willfully violate environmental laws or regulations. And sometimes those can even apply to corporate officers who may have had no direct knowledge of the environmental violations, but nevertheless were the responsible corporate official in the eyes of the regulators. So self-audits are equally advisable when acquiring a company or a business unit that engages in any type of manufacturing or industrial operations. Without such inquiry, it's really difficult to assess whether or not your newly acquired business is prepared to successfully withstand an environmental compliance inspection. Sometimes what happens is you buy a new facility or a new company, and lo and behold, just a few weeks or a few months later, an environmental inspection occurs and there's a big problem, which may jeopardize the ability of that company to generate income. It's also much easier to include a budget for pre-acquisition due diligence into the scope of the overall deal than try to find money for such an investigation later on. What I've found in my practice is that if you do your due diligence before the transaction occurs, that all gets rolled into the value of the deal, and it's much easier to pay for, rather than after the deal occurs, you've acquired the facility, and then what happens is it's difficult to get money out of the operational budget to have the facility be inspected and then come into compliance. Most importantly, however, without a pre-acquisition audit, if there are going to be significant future costs that you can identify at that time that are involved in bringing a facility into compliance, the chance to price the cost of that compliance into the deal is basically completely lost at that point because it's very difficult to go back and renegotiate. So, believe it or not, there's a lot of pushback that occurs when EH&S personnel or consultants or company attorneys or outside counsel suggest doing an environmental audit. Why is that? There's a number of different concerns that get brought up, as you can see on the slide. Some of the quotes I've heard of, if we perform a self-audit and discover non-compliance issues, that will just cause problems that will have to be fixed with cost money. And that's absolutely true, but the question is, are you going to fix it now or are you going to fix it later? It's still going to be the same amount of money, and if you get caught by the government, there may also be substantial penalties involved. Another frequent comment we get is that, hey, we've been doing the same thing in the same place for the last 10, 15, 20 years or even longer, and we've never had any problems, so why worry? Well, you may have just gotten lucky. But the fact is, environmental standards and OSHA regulations especially keep becoming more stringent all the time. So what was a best practice 20 years ago may very well not be a best practice today. And of course, if management doesn't care, people working on the line or in lower supervisory positions may get the feeling that bringing up environmental compliance issues is not welcome. And that's a matter of corporate culture, and it's up to upper management to instill in your employees and your supervisors and your management personnel that indeed environmental and regulatory compliance is important and is a value of the company. To pause for a second, there's a big difference between a Phase 1 environmental assessment, or ESA, and an environmental compliance audit, or an ECA. These two kinds of reports and investigations are often confused. However, they're completely different. So a Phase 1 environmental audit is typically used to perform environmental due diligence prior to acquiring title to a piece of real property that may or may not be improved with a building or other real estate or other structures. Performing a Phase 1 is often used to establish all appropriate inquiry, which is a requirement for asserting certain defenses under the Comprehensive Environmental Response, Compensation, and Liability Act, also known as CERCLA, and the most common of these defenses is the bona fide prospective purchaser defense. However, typically Phase 1s are used only when you're looking at a piece of raw land or real estate. If a building is involved, and especially a facility that's operating as a going concern, these types of operations are not typically covered by a Phase 1. A good environmental consultant, when they're performing their Phase 1, may note possible compliance issues, such as not having a correct permit or having unpermitted discharges or things like that. But it really is not the focus of a Phase 1. Typically, the focus of a Phase 1 is on identifying recognized environmental conditions, or RECs or RECs, that would suggest the release of hazardous substances and/or petroleum on the property. So when a consultant is performing that Phase 1, a very good consultant will look at and note some of these things, but that is not their main focus, and a Phase 1 is basically just not the same as an environmental compliance audit. Therefore, for any type of deal that includes acquiring a facility or a company that is operating a business as a going concern, an environmental compliance audit is always a good idea in addition to a Phase 1. If you do only a Phase 1, you may be lulling yourself into a false sense of security that in fact a facility is completely in compliance with environmental and other regulations, when really it's not. So, why do we need an outside consultant to perform the environmental risk assessment? Oftentimes, if you have EH&S personnel inside your company, you may say, well, we're just going to handle this internally. It'll be much cheaper. It'll be better because our people internally know our operations the best. Well, there are a number of disadvantages to simply using internal people for this. First of all, you may not have all the available resources internally that you would wish. Either you do not have personnel with the proper training, or they are busy running the day-to-day operations of the company, or things like that. Also, you have a real concern with objectivity. If you ask the EH&S supervisor to perform an audit of the operations that he or she has been performing over the last several years, obviously any normal person is going to be somewhat defensive of the way they've been doing things for that period of time. So clearly, if you bring in an outside consultant, you're much more likely to have a better measure of objectivity. And of course, you have a conflict of interest with the internal EH&S person identifying those problems. A very important part of this, however, is not simply retaining a consultant to perform the audit, but also retaining the consultant through legal counsel. So why do we need outside environmental counsel to be involved in retaining the consultant to do the audit? The reasons are similar to why you would want an outside consultant to perform the actual environmental investigation. Some companies may have experienced environmental counsel in-house. However, it has proved difficult for some courts to be able to distinguish between the activities of in-house counsel acting as a business advisor to when the in-house counsel are acting as a legal advisor. So judges increasingly seem uncomfortable ruling that an internal lawyer is acting as a legal advisor when arranging for an environmental inspection or audit, as opposed to an outside legal consultant or a legal advisor who seem to get more of the benefit of the doubt from the judges when looking at the issue of whether or not they're acting as a lawyer or acting as a business consultant. At least one court has rejected a claim of privilege for a third-party consultant's technical report, even though the company's general counsel had ordered the report, and the citation for that case is on the screen. Thus, my recommendation is that the safer course of action is to first retain your experienced outside environmental counsel, even if they coordinate closely with internal environmental counsel, who will then retain the environmental consultant. Of course, who pays the consultant's bill is always a question. It's not necessary for the consultant to run their bill through the outside environmental counsel, but it probably doesn't hurt either. Now, of course, one of the main reasons for engaging the outside environmental legal counsel to supervise and retain the consultant is to maintain attorney-client privilege on the report. It's important to know that the claim of attorney-client privilege or the work product doctrine can't protect facts, and the facts that are most commonly come up in these sorts of audits are test results. For example, if you're doing effluent discharges and testing that effluent, or if you're looking for contamination in your facility, the actual test results from those investigations are essentially facts. Therefore, if there's ever an enforcement action or a lawsuit, either from the government or from a third party, and those facts or those test results are asked for in discovery, typically those cannot be protected through attorney-client privilege. However, the narrative of any kind of internal report where you're looking at whether or not your facility is in compliance, again, as long as it's done by outside environmental counsel working with the outside consultant, typically that is protectable by privilege. You then have a much freer hand and a much freer ability to basically be truthful and honest and explain in the report exactly what the compliance issues are, which helps the company then come into compliance. Audits may also have to be provided in the context of a merger or an acquisition, depending on the terms of the contract. So, how does one perform an environmental self-audit? After retention of a competent consultant through experienced environmental counsel, the consultant will provide the plant manager or another responsible corporate official with a pre-inspection checklist. The checklist provides the consultant with basic information such as the environmental permits that a facility has, such as air permits, wastewater treatment permits, hazardous waste storage or management, etc. Also, what laws and regulations are presumed to be relevant for that facility, such as hazardous chemical storage, reporting, and disclosure. Documentation maintained or submitted by the facility, such as Tier 2 reports or SDSs, which are safety data sheets, formerly known as material safety data sheets. And then, of course, spill plans, emergency response plans, incident response, any sorts of plans that explain what happens in the case of an emergency are all things that should be provided to the consultant. After a review of the completed pre-inspection checklist, the consultant will conduct a walkthrough and document review at the facility. During the walkthrough, the consultant will look for circumstances of compliance and non-compliance based on their experience in assessing compliance at industrial facilities. Clearly here, the experience of the consultant is very important, so you want to do a good job in matching up the type of consultant you retain with the type of facility that you have. You want to make sure you have an experienced consultant that has seen these kinds of facilities before and can accurately assess the state of compliance. For example, some of the many issues a consultant will commonly investigate are: does the facility have operations that generate hazardous waste? Are environmental records and information properly maintained and submitted to regulators where appropriate? Does the facility have industrial equipment or operations that emit gases or vapors? And can or will the facility easily be expanded in the future? That last point is especially important because if you have a facility that perhaps is performing at its maximum output based on the permits that are currently in place, if there isn't the ability, particularly in the air realm, to expand the facility, if expansion of the facility is within your business plan, it's extremely important during the pre-acquisition due diligence or during the compliance audit to make sure that if the expansion is important, that the ability to expand your permit is appropriate and allowable by the applicable regulatory agencies. The document inspection is a key part of the environmental compliance audit. Many times the facility looks very clean, but failure to file and maintain the proper paperwork to comply with permitting and reporting requirements can result in problems and penalties just as severe as for mismanaging waste or other more obvious issues. The consultant will review the facility's operations and ensure that any reporting obligations, as well as permits, properly have been fulfilled and adhered to. You need to know where your documents are and how to find them. So after the site visit, the consultant will write up the audit report. The audit report will summarize the tasks performed, including the results of the site visit and document review, and provide a set of conclusions and recommendations. However, a practice tip: the best practice is to first request a draft report to be reviewed by the environmental attorney. The draft should clearly be labeled confidential and privileged, attorney work product produced at request of counsel in anticipation of litigation, or something similar according to your attorney's specific advice. So, what happens after the audit? Post-audit, the recommendations and conclusions should be assessed to determine if corrective action needs to be taken. Consider the following: self-disclosure of identified violations, which we'll talk about in a moment, and whether or not you should come into compliance quietly. In other words, shall we go and confess our non-compliance issues to an applicable regulatory authority in hopes of mitigating or eliminating any penalties, or should we try to fix the problems without going forward to the governmental authorities? After the facility has come into compliance, it's a good idea to set up a periodic environmental audit schedule, typical on a yearly basis. That way, if problems do arise in the future, not only will you be able to identify and address them more quickly, but regulatory authorities typically are more lenient with operations that have a very robust environmental management and audit protocol. And of course, that you can prove by having subsequent years of environmental audits in your file. The best news is that once the initial audit has been performed and the major problems addressed, it is generally less critical to involve an environmental attorney in subsequent periodic audits. That's generally because hopefully you found all the major compliance issues in that first go-round. And then as you perform subsequent annual audits, hopefully everything is now in good compliance order. Part 2, Voluntary Disclosures. The United States Environmental Protection Agency and many state environmental protection authorities provide, through statute, regulation, or policy, a pathway to significantly mitigate or eliminate the typical penalties that otherwise would be assessed, based on self-disclosure violations discovered through the course of an environmental compliance audit. So why should you self-disclose or consider self-disclosing? Number one, and the primary reason, is to avoid penalties. However, a second very important reason is the ability to go forward with a clean slate. I'm fond of quoting one of my favorite authors, Mark Twain, who once said, "If you tell the truth, you don't have to remember anything." And in this context, what that means is that if you can clean up your environmental compliance issues and confess your sins to the government, once you work out those compliance issues with the government, from that point on, you're considered to have a clean slate. That way, as audits come up in the future, you don't have to worry about the government finding past violations through either employee interviews or documentary inspections or reviews or things like that. So the ability to not have to worry about prior non-compliance issues because you've gotten you've achieved mitigation from the government is extremely beneficial and important. While the specific rules vary from jurisdiction to jurisdiction, among other criteria, the non-compliance issue typically must be discovered in the course of a voluntary self-audit. The discovery of the violation must not have been the result of a statutorily required or court-ordered inspection, and the violation promptly must be disclosed to the applicable regulatory authority. After disclosure, the violations promptly must be rectified in order to qualify. The EPA Environmental Audit Policy, formerly titled Incentives for Self-Policing, Discovery, Disclosure, Correction, and Prevention of Violations, safeguards human health and the environment by providing several major incentives for regulated entities to voluntarily discover and fix violations of federal environmental laws and regulations. So the incentives offered by the US EPA policy are 1. Significant penalty reductions, 2. No recommendation for criminal prosecution, and 3. No routine requests for audit reports. We should note here that under significant penalty reductions, that the amounts based on the severity or the gravity of the violation can be reduced. However, the penalty reduction mitigates only gravity-based penalties, not economic-based penalties. What economic-based penalties are typically those penalties that are intended to, quote-unquote, level the playing field, which means that if you have achieved a significant economic advantage over your competitors during that period of noncompliance, the penalties associated with that period of noncompliance and that economic benefit cannot be waived through the self-disclosure policy. There are many conditions for penalty mitigation, all of which generally must be pretty strictly complied with. That's another reason why it's important to have your friendly environmental attorney very involved with putting together a self-disclosure to US EPA or to any state agencies. Failure to meet any of these 9 criteria can be fatal to a proper self-disclosure. If your self-disclosure is not done correctly, what happens in that case is not only have you not mitigated your penalty, presumably, you're also drawing a roadmap to your non-compliance issues to the regulatory authority. Therefore, all of these 9 criteria are very important. So I'm not going to read all of these, but some of the more important ones are systematic discovery of the violation through an environmental audit. So this has to be done, and the violations have to be discovered through your environmental audit. The violations have to have been discovered voluntarily. They have to be disclosed promptly, and we'll talk more about what the time periods for that under the US EPA guidance and the state guidance is. And obviously you need to fix the violations and prevent their reoccurrence. The EPA also provides a specific self-disclosure option when a company is acquired by new owners, and that gives the acquiring entity a chance to start with a quote-unquote clean slate by disclosing the environmental noncompliance issues and setting up a corrective action plan. A specific window for that investigation and disclosure is available that spans both the pre-acquisition period and the post-acquisition period, but it's limited and finite. Under US EPA's audit policy, there's also a new e-disclosure system. However, the e-disclosure system is meant for typical non-compliance issues that are meant to be disclosed to the agency. They're not intended for the pre-acquisition self-disclosure or any kind of major violations that require negotiation with US EPA. As far as the states go, a number of states also have voluntary disclosure programs that provide an audit privilege and/or penalty immunity for self-disclosed violations. State programs include privilege laws, penalty immunity laws, and statutes providing both privilege and immunity. A word of caution. The prerequisites and procedures that must be followed under each of the federal and, where available, state schemes are complex. And again, these require strict adherence to ensure that the voluntary disclosure will qualify for the penalty mitigation benefits. Among other issues with state disclosures, It should be noted that some states don't require submission of the environmental compliance audit to reap the benefits of the self-disclosure policy. This can be advantageous because then you don't have a copy of your self-audit sitting in the files of the governmental agency. Some states, for example Texas, require that the audit can't be conducted until a notice of audit as defined under the statute has been submitted. Other states, such as Nevada, require a state-certified environmental consultant to conduct the audit. Obviously, many states also have differing timing requirements for submitting the self-disclosure, and some states have specific paperwork or forms that must be filled out and submitted. Bottom line, you need to consult with your consultant and your environmental attorney on which particular state your facility is located in, and in companies with many different facilities spread out among other states, you need to make sure that each state has an audit policy and that the audit policy provides for penalty mitigation, and be very familiar with the specific rules in each state to make sure that your disclosures are valid across each state. Self-disclosing violations to a state with an authorized federal program does not resolve federal claims, however, for those violations, and vice versa. Now, the risk of EPA enforcement after resolution through a state audit program is generally very low because overfiling after state audit disclosure and management of the issues under the state's program are pretty rare. The state may open and then close a formal enforcement action to manage the violations in their system. So, the facility may still be listed on a federal or a state website as a violator even after self-disclosing and coming into compliance. That's the end of my video. I hope you found it informative. I'm Larry Falbe. My contact information is on the slide, and thank you very much for your attention.